Right. Right, so we're holding this hearing today at the request of law enforcement and with the agreement of defendant and counsel. This hearing is recorded as required by law and made available to the Supreme Court for final determination. This hearing will form part of a record within the Department of Justice, and today is July 15th, 2025. It is roughly 7:54 p.m. Central Standard Time. To my right, we have Assistant Chief Mike Trill. To my left, we have counsel for Defendant Alice and Defendant Rebecca Winston. So at this time, if I can have, beginning with law enforcement, please state your full name for the record.
My name is Officer Mike Drill. I'm the Assistant Chief here at MRPD.
Okay. Counsel.
My name is Alice May, and I am a public defender for the DOJ department.
And can you instruct your client to also state appearance for the record?
Yes, Miss, can you introduce your...
I am Rebecca Winston, and I'm a civilian, a
Thank you.
former cadet.
Thanks. All right, District Court now calls People versus Rebecca Winston on a charge of criminal possession of a Class 1 firearm without any due licensing. So I do have a report here from law enforcement stating the following. Mike Trill received a call from dispatch that there was a house robbery in Vespucci Canals, and upon arriving on scene, Mike Trill observed that the suspect was leaving the premise or the residence. She stated that she was going to the hospital due to her friend calling her and requesting her presence there. The officer told the suspect that that was fine and that just needed to search her to make sure that she was telling the truth. Officer didn't observe anything too crazy on her person except for a firearm. In this instance, since the search was warranted by reasonable suspicion and permission was voluntarily provided, a warrant was not required.
Excuse me.
Yes?
It would be probable cause, sir.
You had probable cause?
That's correct. I saw her leaving the residence, which gave me probable cause.
And the dispatch call that you received was directly for that address?
That's correct.
Okay. So let the record reflect the correction and replacement of the word suspicion to probable. And then there is nothing incongruent with law so far. It's my understanding that the defendant is also a plaintiff on a previous case. Law enforcement recommended an expungement or suggested, if otherwise, in order to not raise any criminal suspicion that would give or entail or persuade anyone pertaining to that case to have an ill appearance towards the plaintiff in that case. In this case, styled defendant. All right, so let's move on forward to the bottom line. That would be law enforcement. Are you opposed to, in any way, shape, or fashion, that this court show inclination to granting relief for an expungement of this charge? And do you have any uh, recommendations or stipulations prior, as a requirement, prior to the court being inclined to grant said relief, making it a granted relief based upon stipulation?
I'm not. The only stipulations I do have is that her license be, I mean, her case be expunged through the DOJ. Her LTC license is paid for through the LSPD department and given and picked up a physical copy from the city hall, as well as receiving further training not done by the sheriff's department she formerly used to work at, and at least acquiring 10 hours in a range for gun safety.
All right, thank you. So to confirm, the only stipulations you're presenting would be for the defendant here to, one, have a physical license to carry; two, further training consisting of 10 hours in a range in firearm instruction. Did I miss any additionals?
As well as an expungement.
Well, the expungement would be stipulated through those conditions. So,
That's correct. Yeah.
okay,
Just as a summary, the expungement be done and
okay,
sought through.
okay, very good. Counsel for defense, the stipulations presented as a requirement to expungement today are being obtaining further training in a range consisting of 10 didactic and presential range practice, and obtaining an actual license to carry. How do you reply or respond to those stipulations?
I believe that we completely agree with the stipulations here. No further comment.
How?
Oh no, no, you didn't say that, but somebody did.
Give me 1 second. Can I go correct
They
my officers
did,
downstairs, please?
bro.
Sure.
They were just there.
Thank you.
I
Give
told
me
you
one
I
second.
wouldn't
Sorry
lie
about
Sure.
to you.
Alright,
No.
man. But that even say you have the right to remain silent. Anything you say can and will be.
that. Hey,
Well, this is an interesting case.
Uh, we're just gonna wait for him to return before we utter anything else. How you doing, Miss Alice?
Pretty good. I got
Very,
hit by a car, and my
very
body kind of aches, but I'll be fine.
okay. Tylenol, ibuprofen, anti-inflammatory, and ice. But you have to ice pack it
Yeah,
to help
kind of in
loosen
an
it.
uncomfortable place. I got hit on my
Yeah.
back area. I got hit on my back.
Ooh, that's not good. Not good at
I
all.
might consider some physical therapy.
Mm, well, maybe later down the road, after you've healed and stuff, you know,
Yeah, probably.
'cause you can be sore and stuff. All right, so just
Absolutely.
waiting for the assistant chief to return.
sorry about that.
It's okay. All right, so counsel agrees to the stipulations presented. The court would like to ask counsel, how would you ensure that the stipulations are met within the required time frame?
They're asking me
No, I'm
how
asking.
they're.
I'm asking
Oh,
her.
okay, okay.
Yeah, so regarding the stipulations and everything, I think the given stipulations for my client seem completely sufficient.
Okay.
So we do agree.
Okay. So I'll ask, how will you inform the court that those stipulations have been accomplished?
So I believe that the best way to go about it is to check up on my client.
Mhm.
And of course, because these, of course, are court ordered, I will, of course, be going ahead and I will be possibly even physically be there with the client to make sure that she has all the training needed. I will also, of course, make sure that she has her license, her physical license, and her inventory at all times. And I will also be checking out the clinic just to make sure, of course, that she is, of course, doing her hours. And I will also be checking in with PD and possibly my department as well, just to make sure that she's done all her hours on time, of course. So I do believe that my client can do it, and that uh, the stimuli is more than enough for this to happen.
Okay. Um, Officer Trill or Assistant Chief Trill, uh, do you have a recommended time frame for the stipulations to be met?
For them to be met,
Mhm.
I would like for them to be done before her court case is due for her court case due against the sheriff's department.
Mhm.
So at any time before that, so that we can get her record cleared before she goes on trial for that.
Counsel,
Yes, I believe that's completely fine.
can you guarantee district court that the requirements will be fulfilled before then?
Yes, I can guarantee that.
Okay. And at this time, does the defendant have anything to say or wishes to address or waive?
Can I discuss it with my defendant first, quickly?
Yes.
Do you have anything to say? No. Not at this time, Your Honor.
So waive. Okay. The court notes that there is no priors. The court notes that the defendant was fully compliant and cooperative, did not pose an immediate threat or risk to the life of law enforcement, and at the recommendation of law enforcement, district court is inclined to grant relief of expungement at this time. That
I'm sorry, I'm in court at the moment.
that
Sorry
will
about
that will be submitted for approval. Um, Hopefully, law enforcement can take care of the expungement um, before the court is called for hearing the plaintiff versus the sheriff's department. And so, at this time, the Department of Justice, through the district court, does grant relief of expungement, with the next order being declared that any agency, government or otherwise, wherever those records may be in possession of, are hereby ordered by the district court to be incinerated, destroyed, and removed without trace and sealed for no access of any other particular agency, government body, or entity for any purposes or at any time. It is so ordered. Thank you, ladies and gentlemen.
Thank you, sir.